Hi, it's attorney Ryan McKeen, and I'm here with Connecticut medical malpractice attorney Jake Kocienda. How are you?
I'm doing well, Ryan.
And Jake, today we're going to talk about something we're frequently asked, which is what time frame do I have to put forth a medical malpractice claim in Connecticut?
So you really want to try to do it as soon as you can and as soon as you have an idea. It gives us time to work these up and understand the case. But even though it may not be right away, generally you have up to 2 years, with some exceptions, to bring a case against whoever the providers are or the hospital that you're concerned with. For different circumstances that we can get into and we can better assess when we have details, you can bring it up to 3 years, and sometimes in certain wrongful death cases up to 5 years. But generally speaking, it's 2, but the sooner the better.
Yeah, and I think that's sort of an important point, because the law recognizes, you don't have to bring a claim like the day after you've experienced it or the loss of a loved one. You have some time, but it's not forever. There is a bar on how long you can bring claims, so you don't want to wait around, but you don't need to feel like you need to make it the day after. But generally speaking, the sooner you can contact a competent medical malpractice attorney, the more that they're going to be able to do for you. With the caveat being, we're good at reconstructing and doing things. So long as you're sort of within that 2-year limit generally. But if you have any questions about this, because every one of these cases is very factually specific and very nuanced, beyond what we could ever discuss here on YouTube, give us a call and get a very specific answer to your question. You can call attorney Kocienda 860-471-8333.